If you sell physical products on Amazon or any other e-commerce platform and you would like to protect your brand, this video is for you because we will be talking about trademarks, how to register, the difference between types of trademarks, the difference between different jurisdictions registering trademark in US, in European Union. Our guest is Alex CHERNENKO. He runs an agency, Chern Co, which helps e-commerce business owners to register their trademarks in different parts of the world. So if you would like to register your trademark with them, check their links below in the description. And I hope you will enjoy the content Alex shares in this session. Hello, Alex. It's nice to have you here. Could you please introduce yourself and tell us how do you help Amazon sellers?
Hi, Augustus. Thank you for having me. My name is Alex Chernenko. I'm the CEO and founder of Chern Co. And the way I help sellers is with, I don't know, some people call it boring services, but it's accountancy, company information, VAT filing compliance, and most importantly, trademarks, the subject that we're going to talk about today.
Yes, we'll talk about trademarks for Amazon sellers, for brands, for e-commerce brands. Also, besides trademarks, you help with incorporation of companies in Europe, right?
Yeah, we register companies in Ireland and UK as well. UK is outside of Europe's scope, but it's our neighbors, so we can help to UK Amazon sellers too.
All right, so let's talk about trademarks, do's and don'ts. And I know you prepared some slides.
Yeah, I did. So I'm going to take you through, let's say, a state of trademarks in 2022. What are the recommendations? What Amazon sellers, or even not Amazon, but other e-commerce sellers should do or shouldn't do in relation to their trademarks. So just to give you a little bit of background, my own personal journey, I consider myself an entrepreneur with more than 12 years experience. I would be a frequent guest and speaker to e-commerce events, and I'm a very big fan of Orange Klik events. I think I've been to all of them in the last 3 years. I'm running 3 projects at the moment. One of them is Chern Co. That's our law firm helping with the trademarks company registration, but I also have another project that's called Translate, and I was able to raise over $500,000 investment in that project. It's kind of going quite well. That just to show that, you know, as an entrepreneur, I have a couple of different ventures, and myself, I'm also Amazon seller since 2017. So I understand all the pain points that sellers go through because I also have my own Amazon business. And to give you a little bit of the context, at the moment, trademarks require certain level of accreditation. In European Union and in the United States, only accredited attorney trademark solicitors could actually file an application on behalf of their clients. So we actually have those solicitors in the company who are working for us. And we also serve as a European representative or UK representative when it comes to UK trademarks. So I'm going to go through requirements for different trademarks in different jurisdictions on some of the slides. But just to give you perspective that it's not just preparing and filing an application, it's also about where you're located and the accreditations that the company or the attorney would need. So enough about me, just to tell you why it's important to register trademarks and what is the current state of affairs. Amazon, for example, has a huge counterfeit problems. So one sellers are trying to copy the work of other sellers. And because of that, there is a number of lawsuits that happening against Amazon. Amazon always are doing something to protect the sellers, but at the same time, many sellers believe it's not enough. And if we look at what's happening, for example, that more than 6.8% in non-European countries are actually counterfeit in European Union. So there is approximately 7% of the goods being imported, they are actually fakes. And if we look in America, that figure is even a little bit bigger. But because we're based in EU, we focus on Europe and we focus on the America. And because of that, Amazon is actually facing a number of lawsuits. So what they have done, they introduced the concept of brand registry. They introduced the concept of Amazon Project Zero. And this is their way to reduce their legal fees against those counterfeit goods. For those of your viewers who are the first time dealing with trademarks and they have no clue what a trademark is, I think it's going to be good just to cover the basics. So a trademark is essentially a word, a phrase, symbol, even sound, that smell, a color, a shape that is clearly identifying one brand over the other. So ideally, it's not just a name or essentially a logo or image. It could be any of those. So trademark could essentially be more than just a name and an image. And sometimes people ask, what's the difference between kind of these two little icons, TM and R? And people confuse TM with essentially a registered mark. Well, in fact, the TM in the circle means that the brand is just claiming the ownership, but they're not necessarily registered. So when you see an R in the circle, that means that that is actually a registered trademark. So R would be a better option, and it could be used by the registered trademarks. So it's, again, it's a basics, but many people confuse it. They think TM is a better option, but TM is not a proof of registration. Going next, why people need trademark? That's probably the first question they ask. Like, okay, trademark, who cares? Well, essentially, trademark ensures brand protection against copying and also against future potential legal use. Trademark also leads to a brand recognition. Some businesses grow to sell their companies at the end of the day with Amazon, and if that business has a trademark, it essentially becomes an asset, and it could lead to a better sale. So when somebody is buying the business, they prefer to buy businesses with brands. When a trademark becomes so recognizable, it's also good for hiring and retaining staff, because people like to work for businesses that are associated with brands or with some recognition. Believe it or not, but also trademark could be used as a tool to prevent importation to United States of some goods. So essentially, a trademark owner could contact US imports, and if they believe there is certain counterfeit product that is breaking their intellectual property, they could stop the importation at the point of customs. It's possible to do it in the United States. Also, trademark could be used as a tool against sub-squatters. So if somebody is trying to buy domains that relate to your brand, you could use trademark to actually prevent that. And of course, most importantly for Amazon brand is that trademark give access to brand registry, which is what Amazon sellers would like to have. And to give you a couple of words, what Amazon brand registry is just a tool that Amazon offers to the brand owners. What it does, it's supposed to be protecting not just the brands, but also the customers. It also gives kind of a faster customer support to the brand owners. And it's essentially protecting against counterfeit or copies. Just a couple of bullet points. So essentially, the main reason for Amazon brand registry is enhanced brand content. So Amazon sellers, they are given an ability to put more images, more media files onto their Amazon listings. And that essentially makes their store beautiful. Also, brand registry owners could have essentially an e-commerce website on the Amazon platform. So it allows essentially to display the shop as it is a different website inside the Amazon marketplace itself. It also gives additional brand analytics, so brand owners get access to more data than an average person. It also gives an additional search facilities, and it's a faster support by Amazon. So that's just some of the things to keep in mind. And this is a couple of examples how Amazon brand registry websites could look. So as you can see, it looks like essentially a website with a lot of graphics, text that could be embedded onto the shop and listings. How to get a brand registry? There's a couple of requirements. A seller must have an Amazon seller account. They need to have a proof of ownership or authorization from the owner. So it's not necessarily for the owners of trademarks. If, for example, an Amazon seller is selling brand on behalf of somebody else, and that brand essentially issued a letter authorizing this seller to be selling on their behalf, they could show it to Amazon, and they could also get access to the brand registry. So essentially, the owner of trademark authorizes somebody else to sell on their behalf. It's also possible to do it this way. And to have an Amazon brand registry, it requires a registered trademark, or it requires essentially an application via IP Accelerator. I'm not sure if you're familiar with IP Accelerator, but I'm gonna describe it. Essentially, what Amazon did, they added a couple of trademark registration providers to their website. And if the application to register a trademark is going through them, they allow sellers to essentially receive a brand registry account activated within 10 days, even before the trademark gets registered. If the seller goes outside of IP Accelerator program, they need to wait until the trademark is registered, and only then they can get access to brand registry. So for people who really want to get it fast, they go through IP Accelerator program, but it's going to be a little bit more expensive. So essentially, IP Accelerator solicitors, they charge more fees than a typical trademark attorney. So if the budget is not a concern, it's the speed, then IP Accelerator would be the good option to apply for brand registry and trademark. But if the cost is the top priority, then probably IP Accelerator could be skipped. Now, some sellers and brand owners believe that once they get a trademark registered, they don't need to do anything and they could just sit and relax and they're protected. It's not the case. A brand owner must ensure that they monitor their trademark. And this is just an example that one seller could take your product, change a little bit of the wording, and try to sell it under their name. It could be that somebody else tried to register a trademark that is a slight variation of your trademark. So a seller should basically every month or every 2 months check if anybody else is trying to register a trademark, or they could hire somebody like ourselves or somebody else to monitor trademark regularly. What it will ensure that if somebody tries to register a similar trademark, they will see that and they will be able to object it during the window. Normally, trademark registrations are given about 3 months of objections, depending on jurisdiction, like if it's UK, if it's European Union or United States. But usually it's kind of on average 3 months of objection period. So during that time, if you spot that somebody is trying to copy you or do something similar, you could object and you can win it and that trademark will be stopped. But if you don't do anything, it could be registered, and then it's going to be very hard for you to compete with that. So monitoring is something that businesses should do after their trademark is registered. Quite often, I'm also asked, should I register a trademark as an individual or should we put it on the company? What's the benefit? Why one option is better over the other? And I have this little comparison that I'm going to explain to you in the moment, that if you are registering as an individual, your personal details, such as your mobile number, your email address, your home address, will be publicly visible. And that's sometimes something you don't want to be explained. If you have a business like a company, the company address will be published, which is already public information. If the individual is owning a trademark and something happens to that individual, all the rights will be inherited by the next of kin. So if, let's say, a person dies, it's going to be, it's a long process to get the ownership of trademark to move to the inherited person. On the other side, in the company, if one director leaves or shareholder, the intellectual property remains with the company, so it makes it very easier to reassign. But with individuals, it's not going to be so easy. Also, if anything happens with the brand and there's petitional legal case, mitigation, or issue, the owner of a trademark will be personally liable for those, which means if they have property, that property could be confiscated in the cases if they lose. If any legal action happens against the company, the individual kind of becomes a separate entity and protected. So again, if there is any serious implications, the individual could be personally liable for that. But if it's registered on the company, company is liable, and company is usually has limited liability. And finally, if a person plans to rent their trademark, license it to somebody else, or sell it, any income would be taxed on a personal tax, which is normally quite high for individuals in certain countries. But if the licensing is done by the company, companies have efficient way to essentially pay taxes and regulate it and move it into different entities. So from tax point of view, doing it on the company is also a better option. So a recommendation is, of course, to see what your personal circumstances is, but company is winning by a number of those points. When it comes to trademark licensing, that's something that we see now more and more used. So some brands allow their brands to be used by other sellers. And essentially, it's very simple to set up. There is a couple of template agreements that could be used, and one person gives permission for, let's say, a fixed monthly payment. And essentially it becomes like renting a car or renting something else. It's just the monthly payments. Normally royalties and trademark licenses, they would be taxed at a higher rate than a typical tax. So we see, for example, royalties, trademarks, they would be taxed at 33% in some countries. So again, this is something that a person needs to check before they go this route, because it could be ending up paying 1/3 of the income just on taxes. So trademark licensing, talk to a professional before doing it yourself. That's the recommendation, with a professional tax advisor in your country. Another typical question: should we register colors or black and white option? Does it matter? Well, actually, it matters in European Union more, because since 2014, the black and white trademark and color trademark, they're considered separate. And if you register one and use another one, then you would not be protected. So essentially, if you're registering color but you're using black and white, you could be not protected 100%. In the United States, on the other side, it's kind of a little bit more relaxed, more acceptable. So if you're using black and white registration and you're changing colors, then it's a safer option than in the European Union. For example, in some cases, like in the United States, there is a strict requirement. In order to register trademark, you need to be using it. In the UK, for example, and European Union, you could register a trademark without using it. But in the United States, you actually need to show that that trademark is applied on a product or packaging, for example. But there is an option how to avoid that. If you only have a name, but you don't have it anywhere published and you cannot prove it, you can actually register a trademark with intent of use. What it means, that it's like a reserve in a trademark name. So you have it registered, and then you could extend it every 6 months until you actually start using it. And you can do it like 6 times. So every 6 months, you could extend it for another 6 months, until your product is manufactured, until you put a label, and then you can prove, now I am actually starting using it, please register it 100%. So that's only an issue in the United States. It's not an issue in European Union or UK. You could get trademark registered before it's actually on the product. But in US, you need to prove it. So that's the option how to do it. Do it with intent of use. Once you start using it, then finalize the application. But so it becomes essentially a 2-step process, and it's a little bit more expensive, of course. So it's better to register it if you already start using it. But if not, this is a way to go. Another option and question we typically get asked: should we register a name or should we register a logo or the image? What's the better? From many trademarks that we have registered, the conclusion is as follows: that if you have essentially the same classes, the same application, the image gets higher probability of successful registration. So the image is considered to be more unique by the patent offices. And sometimes if there is a similar name to some level of degree, there is a similarity, the risk of getting rejection with the brand name is higher than registered as an image. So what we typically now find, and maybe even recommend to the clients, that if there is a slightest risk of rejection because of similarities, even very far similarities, register an image first, and then after a couple of months, apply for a brand name registration. That kind of gives a higher probability that both trademarks will go through. But if you apply just for the name first, there is a chance. So the chances of rejection with the brand name are slightly better than the image. That's what happens. Now I'm gonna run through a couple of common mistakes that happen with trademarks and how to avoid them. So the number one reason for rejections and refusal is people not doing enough trademark search or doing a poor search. And later, I'm actually going to show you what a poor search is with a specific example. So do the trademark search. You can do it yourself using some websites that I'm going to share on later slides, or you could ask this any trademark professional to do it for you. Now, not using a trademark anywhere. If you're trying to register trademark without any usage, for example, United States, as I said, you need to be using it to get the full registration. Not having business name or local registration. Now, many businesses, they register company or a business name, and then they apply for trademark. Some people skip this process. We recommend actually having a local registration first before going on the nationwide registration. When people try to register brand name that is descriptive and there is no uniqueness, for example, you are selling chairs and you have a trademark that you call it chair. That's not unique. That's not descriptive. That's basically, a trademark is a word of what actually a product is doing. It's not going to get registered, or very unlikely that it's going to get registered. So the trademark needs to have a uniqueness to it. It shouldn't be descriptive. That's actually what many reasons for rejections that we see with some of the trademark registrations. Using personal names and surnames, it's not advised. The only applications with personal names and surnames, if you have a family business, let's say for 10, 20 years, you've been selling something under your family name, then you have a chance of getting it registrations. But any new registration without previous history unlikely will get registered with names or surnames. Sometimes people are trying to use someone else's brand. Maybe you saw a trademark in one country and you're trying to register trademark in another country, and you think you're smart. Don't do it. Very likely you're going to get object. Or sometimes you're trying to register trademark just by changing something into it. Again, don't do it. It's not recommended. Sometimes we see people registering a trademark for specific classes, but then they're using trademark for another classes of products. So basically they think, if I registered my trademark on toys, I could also use on, for example, food buds or something like. No, you cannot do it. You can only use a trademark and be protected if you use it on the goods that you actually declare during registration. And it's not possible to add trademark classes. Once you registered your trademark for specific classes of goods, if you want to extend it to other products, you need to register a new trademark with those classes. So some people basically have like 3 or 5 trademarks with exactly the same name just by adding new classes and having to go through the same registration process. But there is no way to actually change the trademark once it's registered. It's only possible to add new ones. Now, again, registering trademark in someone else's name, that's also a mistake, because if something happens, it's going to be very difficult to prove the ownership. So ideally, the trademark is registered in the actual owner. Doing this kind of structure where somebody is holding the trademark rights could be a mistake, but some people prefer to do it for whatever reasons. We're not going to discuss them. Now, using variations of trademark. For example, you registered an image, but then you decided to change a letter or add additional graphics element. Again, that means you'll not be protected. Sometimes people forget to update contact details. For example, trademark is registered, they created a specific email address, then they lost the password for that email address, and they never updated it. Well, if there is an objection or important communication from the patent office, it goes to the contact details that are on file. And if that email is no longer active, basically a person will not get that notice. And that actually has led to some of the cases where a person lost a trademark or was actually fined and had to pay and lose money as the result. So ensuring that you have active contact details is very important. And people forget it. 2, 3, 5 years later, people change emails, change website, whatever, and they forget to update it. So make sure you keep your details up to date. Spelling mistakes, not following application guidelines. Many applications, they don't necessarily get rejected, but they get office actions. That means that an application needs to be updated and resubmitted, and that normally creates costs, additional costs to the brand owners. So make sure when you update the application, there's no mistakes. Everything is the application is done correctly. If you do it through professional, that normally doesn't happen. And of course, final number 13, doing it yourself without professional help. Again, this is something that some people choose to do themselves. But for example, in European Union, if you apply for a trademark registration and it gets objected and you don't respond, you just leave it like this, you could be liable to pay the legal cost of the other party who did the objection. And we had one case where a person did the application, then decided, oh, I'm not going to do it, let the other person win the case, and they had to pay like 600 or 700 euro cost. So if you're doing it yourself and you're thinking, worst case scenario, I'm just going to not do anything, that's not the case. You could not doing anything could actually be an additional money to be spent. So, think twice whether you want to do it yourself or trust this to a professional, because you could be liable for additional costs of the other party who is objecting if you don't do anything. What to avoid? We kind of covered the mistakes. It's just, avoid simple brand names, common words, avoid using colors or shapes as a trademark, avoid kind of trademark that talk about quality, quantity, purpose, value, geographic origin. For example, if you call it by the city or country, that's not recommended. Time production, or other characteristics. So, the trademark has to be unique. If the trademark is so obvious that it explains what it is or how it looks, unlikely it's going to get registered. Most likely it will be rejected. Don't use trademarks that have some similarities. Don't try to create confusion. Don't use slogans unless you are like Nike or Coca-Cola, who have a really good legal team and you want to register slogan. It's not advised. Slogans are you need to prove that it's really recognizable, that it's widely used before you can get registered. And it's usually expensive to register a slogan. Avoid names and surnames, as I said, and avoid changing context or failing to update them. And finally, some people go to Fiverr and they see like, I'm going to register a trademark for $5. That's not the case. Don't trust those amateurs. Registering trademark for $5 should be raising a concern with you. Okay, now I'm just going to take you through a couple of examples with different jurisdictions. In United States, $250 to $350 per class is the current fees, plus whatever solicitor fees or attorney fees if you're engaged with consultant. The registration normally takes, on average, 7 to 9 months, assuming it goes fast. If there is any objections that has to be responded, it normally could take up to a year. So 7 is like the very optimistic registration. 9 is the more likely. Average registration takes about 9, and then it could stretch up to 12 months if there is at least 1 or 2 objections. And it's valid for 10 years. Now, non-US residents cannot file trademark registration themselves. You have to use a solicitor. So if you are based in Europe and you're registering trademark in US, you have to go through a solicitor. You cannot do the application yourself. And as I said, be prepared for office actions. It's very common. The statistics show that more than half applications actually get at least 1 office action. When we look into United Kingdom, which is also outside of European, this is the easiest and probably the quickest trademark registration office. Germany is also quite good. The current fees are £170 to 200, depending on which application you go through, and £50 for each additional class. Registration normally takes 3 to 4 months. It's also valid for 10 years. And pretty much anyone can file this application, even the businesses themselves. But in order to register trademark in UK, they need to have a UK address. So it's essentially, going through a representative is the best option. So for trademark application must have a UK-based address, and for that you normally need a representative. When we look in European Union, it must also have a European address, but you need to use essentially an approved European representative by the patent office. You cannot just take any company, your friend, and you say, can I use your address? That's not the case. It has to be done through a professional trademark attorney. European trademark fees are one of the most expensive, €850 for the first class, and then €50 for the next 2 classes each. And then if you have 3 or more classes, you pay additional €150 for each class, which makes it quite expensive. Timeline, it normally takes between 3.5 to 6 months. It's also valid for 10 years. But there is an option of going through European fast track, which is like 3.5 to 4 or 5 months max. And it's essentially, if you're not doing any custom, if you're using essentially all the options that are presented by European Union, which essentially using their database of classification, database of classes, it's upfront payment, and you're also accepting the translations from European Union if your trademark is in non-EU language, for example. And there is no priority claim. What is priority claim? If there is a trademark registered in another European country, you're applying for the whole European Union, let's say taking German trademark registration. So you could have the European Union trademark have the same date as the other already registered trademark. That is called priority claim. So if the application has a priority claim, it cannot use fast track. But if you're not using priority claim, you could actually apply for fast track and get it registered under 5 months from the date of incorporation. Now, I want to share some good news. There is actually a grant available now for European companies or European individuals who are based in the European Union to get up to 1,500 of grant for the trademark registration. It's called SME Fund, and actually it's been there for last year, but the current grant amount for in 2022 are higher. And I'm going to give you now a couple of slides how it actually works. So there is four grants in total available. IP scan, when you are hiring a professional to essentially see what intellectual property you have, how you can protect it. So this is called consultancy services for IP scan. It's probably not as much relevant for Amazon sellers. What is more relevant is trademark in design. So if somebody is based in European Union and registered European trademarks, they could get up to 75% refunded to them. So consider 1,500, 75%. That means you could register like two trademarks and only pay essentially 25% of that cost. Now, if you're registered trademark outside of the European Union, you can only get 50% of the grant. So, for example, that's also nice grant, but 75 obviously is better. And then if you're applying for patent, you could also get 50% of that refunded. So how actually it works, a person applies, and pretty much within 1 or 2 weeks, they receive a letter that they are awarded this grant. Then they're given 4 months to register a trademark, and they're given a voucher. So, giving you a basic example, I'm applying for trademark. I'm paying 850 euro per class, and I'm registered 1 class. I'm going to get 75% back, which means it's like 600 something euro. If I'm applying for 2 trademarks and I'm paying 900 euro for 2 trademarks, again, I'm going to get 75% of the back. That will be about 1,300. So this is a good way for European individuals or companies to get this grant. It's now available. If you're interested, you can contact me or go to SME Fund website yourself and read all the information. But that's the best time, 2022, to get your trademark registered under this European funding. Now, if we compare registering trademark through the European Union Patent Office or actually going through the Madrid Protocol, what is the Madrid Protocol and why some people would like to use it? It's issued by the World Intellectual Property Organization Office, and it's normally there's more than 150 countries in it. And the way it works, you have a trademark in one country, and you're using that trademark to give you protection in all the other countries, of which WIPO is a member of. But it takes about between 12 to 20 months. It's more expensive. You need to have a registration. You need to have a legal representative, and it's a paper application. It's still done by paper. And you need to have at least trademark registered. If you want to get things quicker, you don't have a trademark registered, you go directly to the European Union Patent Office and you apply for European trademark, which takes, between 3.5 to 8 months maximum. As I said, you can do it yourself if you have a European company or if you're a European individual. It's online application, and it's usually a cost-saving option. And this is just an example to show how expensive the Madrid Protocol could be. If you're taking a basic example, like 1 trademark with 3 classes, and assuming now the grant that's available for European Union, that is like 5 or 6 times more expensive if you register trademark right now. So what I'm gonna show you now, as promised, a couple of examples when you're searching for trademark and we're doing the initial analysis. So this was a real example. There was a basic search done. There was no indication that there was some sort of risk of registration. Then the person filed the trademark registration. They got an office action with likelihood of confusion, and it resulted in additional 500 legal fees. So I'm going to show you how it actually happened. So let's say you have a trademark. A person used a website of United States Patent Offices themselves. They didn't do it through the professional attorney or expert. So they typed in a word. In this case, it was ALBO, for example, and they saw that there was 11 results, as you can see. 11 results, basic search. They're like, okay, there is nothing similar. Those trademarks are dead or live. I'm pretty much covered. Now, what that person didn't do, they didn't do an additional search, which would show a little bit more results, and this is, for example, as you can see, it shows less results than on the previous screen from 11, but actually it spotted this trademark, Albojes in this case. So again, I'm going to show you. This showed 11, and you do not see that particular trademark on this screen. But with advanced search, using special algorithms, using special kind of arguments, this trademark could have been spotted. And if it was spotted, the application probably wouldn't have proceeded, because this one is actually quite similar and it's in the same space. So the risk is actually was much higher than from results on the previous screen. So that's essentially what differentiates from good search and bad search. And individuals who are doing it themselves, they don't necessarily know how to do these searches like a professional. Another reason would be like using tools like Trademark now. It's actually a premium tool and you have to pay for it. But if you're using additional kind of aggregators of searches, you could spot these things there, but you have to pay to use the services. And as you can see, this one showed the conflict in Trademark because it's a premium service. And it shows information. An individual does not need to use how to apply these arguments, but they will need to pay for the service like this. So again, this is an option for somebody. Somebody could, do an advanced search or hire a professional or pay for a tool that does a better search than official patent office. So where to do those searches? As I said, Trademark now is one of the services you could use. Now it went through rebranding, so it's called something different at the moment. You can use official websites. For United States is USPTO. For United Kingdom, it's government.uk. For European Union, it's EUIPO, and then for Madrid Protocol is WIPO. And there is also really good search aggregators. Its official resource, it's called tmdn.org. That's actually official resource by European Union themselves. So they have tools like TMView, TMClass, DesignView, which you could search by brands, or you can search by graphics and designs. And actually, it shows not just European Union, it shows the whole world. So TMDN is like one of the best services available out there at the moment. It shows registered trademark, dead trademark, and even some applications. Another tool I would recommend, namecheck.com. So let's say if you are considering registering trademark and there is no other trademarks, but you still want to check if there is a similar website, if there's social media accounts, or even some mobile apps registered, you could use namecheck.com and it would show you what exists out there. It's not trademarks, but it's actually a kind of online resources that are publicly used. Because if you're building a brand, you want to get a social media account for it. You want to get a website. You want to get, a couple of other publicly online available things. And trademark, you can get a trademark registered, but if you cannot get a social media account, or because somebody else is using a similar name, that's not going to be good. So I recommend using namecheck.com in addition to checking trademarks, because it's going to give you a wider knowledge, and you can then see, okay, no one else is using this name anywhere on the internet, which is good. I can register a domain, I can register this and this. So that's kind of comes to an end of my presentation. What I would like to do, Augustus, for your audience, we're going to do essentially a special promo for anybody who watches this webinar. And if people are considering applying for trademark and they want to avail of a discounted price, they could fill in this form, which is going to be bit.ly Orange Klik. And once they completed it, it will come to us, and essentially we will apply the discounted rates to either perform a search of trademark or to register trademark. And it doesn't matter if it's UK, United States, or European Union. That's all for me. Let's maybe answer some questions from yourself.
Yeah, great. Lots of great information, very practical with good examples. Thank you very much, Alex. And you were mentioning about that, for example, if you register in UK, you need UK address. If you register in US, you cannot do it if you are a foreigner, let's say European person or company. All this you can help with, right?
Yeah. I mean, personally, we have an Irish-based solicitor who looks after Irish and European trademark. We have a solicitor in United States who look after US, and then we also have a UK entity for that. So yeah, like all those three aspects would be covered.
And what would be your advice for the seller, Amazon seller, which is just starting? So they are now working on a product idea. They maybe found a product and they are thinking of, they have maybe a manufacturer, and at the same time they're thinking of branding. And so they have to do trademark first, right? So like, what's your advice in terms of that?
It's a tricky area because some sellers, they make first, they start using a brand and then they register it later after basically, after the brand gets some momentum. Some sellers, they are afraid that the brand will get registered by somebody else, so they register it kind of together with manufacturing or even before. And then we see also some sellers who don't even have a brand. They register it, but they're not using it then for a year or two, and because manufacturing takes time. So the advice is, of course, to get protected, apply for registration as early as possible. That will also give you a brand registry on Amazon. But at the other time, if you have a limited budget and you cannot do like all the European trademarks, American, United, like if you don't have a budget to register trademarks in multiple countries, you can start with something small. You can just start with one trademark and take it from there. I mean, it depends on the budget. It depends, whether you're using the product already or not. And it depends, of course, on the speed, how fast you need brand registry access on Amazon. If you want it faster, you have to start early, or you have to use more expensive IP Accelerator program. So I think the person would need to make their own decision. The basic requirement and basic recommendation is get registered earlier so that you will be protected earlier and you get early access to the brand registry. That's it.
Mm-hmm. And from your experience, probably you get people coming to you, hey, we're in business for 1 year, now we want to register a brand on the trademark office, and then they are refused. So do you have such cases?
Yeah, quite often we get businesses that essentially already are using brands, and then when the time they want to register, it's already too late and there is somebody else in the similar space, but they already used their product, they cannot change it. So sometimes we get application that a person is aware that there is a high risk of rejection, but they still want to try. They say, okay, let's try, maybe the other party does not object. So sometimes we have cases like this. Sometimes we have cases where, there is no objection. Sometimes a person applied, for example, to American trademark, registered, but then didn't use it, and the trademark application became irrelevant. So they applied too early before they got the product manufactured and done it, and that application kind of expired because it was not extended. So many cases, many examples. We can talk about it until tomorrow.
Yeah. All right, perfect. So once again, can you give us an overview of what kind of help and services you can provide to Amazon sellers?
I think the start is always to do a search and analysis. That's not before you spend, let's say, a couple of hundreds euro or dollars on application. Spend $70, $100 for a search, and that kind of will mitigate most of the risk already. So the basic advice: do the search. If you do the search yourself and you don't see anything, probably there is nothing, or there is a possibility you didn't do good search. If you invest a little money and you hire somebody, you'll get not just a search, but analysis. And that will basically give you an idea, okay, you can proceed with it because there is no risk or very low risk, or you basically know that there is a high risk. And then you can think, well, maybe I change my brand. So start with the search risk analysis. That's the very first step. Once the step is done, then basically decide which country you're going to be selling the goods and apply for trademark for that. So what we do, from our point of view, we can consult, advise, help with the application, or provide that address services. If a person wants to do things themselves and they just want, let's say, an address or representative, we can help with that too.
And if they want to do just a investigation of the brand name and to search the trademark databases, they should better do it with a professional lawyer, right?
Well, as I said, searches could be done by trademark professionals. They don't need to be necessarily lawyers. For example, we offer two levels of searches, like a basic search and advanced search. So basic search would just look at kind of patent offices, current trademarks, and current applications. The in-depth search would also look for other conflicting areas and brand names that would be registered in beyond just the patent offices. For example, local registrations in that country. So it basically it goes next step in terms of potential risk that there is already for example, in that country, there is already a registered business with the same name that's been operating for so long, but they didn't register a trademark. That is a risk factor. So, the deep search normally spots that. And final service that I mentioned in my presentation today, monitoring, trademark monitoring. Once you get registered and you want somebody to monitor it on a monthly basis, send you a report, there's nobody trying anything, or actually there is somebody who's trying to hijack your brand, you should do something about it. So trademark monitoring is another service that a person could do themselves, or they could delegate, could come to us, or somebody else in this space.
All right. So yeah, we'll put all the links below. Also, if you need help, not only with trademarks, but you need help to register a European-based company in UK or Ireland, Alex company and team can help you as well. Thank you very much, Alex.
Thank you for having me.
I hope you got some good information about registering your trademark for your brand. If you need help with that, check the link below for the Alex Chern Co company, and they will be happy to help you with registration and advice. And now I would like to invite you to watch other video where Chris Rawlings is talking about enhanced brand content and how to do it the right way to get most conversions.